George Jouganatos has been a college lecturer for over 27 years. He has taught economics, finance, management, ethics, and quantitative analysis at the University of California at Davis, University of California at Santa Cruz, California State University, Sacramento, and the University of San Francisco. Dr. Jouganatos is in demand as an expert witness for cases involving personal injury, wrongful death, wrongful termination, employment discrimination, economic loss, business valuations, lost profits, and divorce. He has consulted and given testimony for numerous attorneys in California as well as in New York, Nevada, Iowa, Montana, British Columbia, New Mexico, Oregon, Pennsylvania, and Hawaii. He has consulted in approximately 700 cases and for more than 175 law firms. On many occasions, Dr. Jouganatos has provided commentaries on economic events and issues for television, radio, and print media.
Thank you for joining me today in my discussion of the effective use of experts in litigation. Litigation often involves issues which require technical and specialized knowledge in order to be understood properly. From the California Jury Instructions Code, an expert witness is a witness who has special knowledge, skill, experience, training, or education in a particular subject. So this type of witness is considered an expert witness. Very broadly for now, the role of an expert may take various forms, including consultation to assist in evaluating a claim, performance of experiments, tests, analyses, or examinations on physical evidence, data, or persons, preparation of written reports, setting forth findings, opinions, or conclusions, which may be utilized to resolve or settle a claim. Fourth would be testimony at a hearing, deposition, or trial to render opinions or assist in establishing certain facts. And finally, fifth for now, to serve as an advisory capacity at trial or in preparation of litigation. Well, regardless of the role in which the expert is retained, he or she must always strive, very importantly, to be objective and independent. It is this obligation of any witness, including experts, to willingly provide information which will assist in truth-finding function in the judicial process. Expert witnesses have been used more and more frequently in both criminal and civil courts, civil proceedings, criminal proceedings. Many times these experts present information from direct examination of participants, and at other times experts are called upon to present relevant research, all of which may serve to assist the jury or court in weighing information that is relevant to the judicial decision-making process. Well, a little bit on ethical principles and principles of professional practice. These are rather intuitive and common sense, of course, but they do come from one of my associations, of which I'm a member. Practitioners of forensic evaluation should decline involvement in any litigation when they are asked to assume invalid representations of fact or alter their methodologies without foundation or a compelling analytical reason. Another ethical principle is in regards to compensation. Practitioners in expert witness litigation should not accept contingency fees or contingency fee arrangements or fee amounts associated with the size of a court award or out-of-court settlement. Another principle, and mind you, these are all, to me, very important for both the attorney and the expert to keep in mind. Practitioners should employ generally accepted and or theoretically sound methodologies that's based on reliable data. And these experts should attempt to provide accurate, fair, and reasonable expert opinions. They should recognize that it is not the responsibility of the practitioner to verify the accuracy or completeness of the case-specific information that has been provided. Very important as well, experts should stand ready to provide sufficient detail to allow replication of numerical calculations and so forth, in which these calculations can be performed with reasonable effort by another expert. And the experts should be prepared to provide sufficient disclosure of sources of information and assumptions that underpin their opinions, so that these opinions and the assumptions and methods are understandable to others. I find it very favorable in reports where there is a narrative, okay, a narrative discussion and background, so even a layperson can follow, as opposed to just presenting Excel spreadsheets of numbers, for instance. Another ethical principle is to be consistent. Experts might be given different assignments when engaged on behalf of plaintiff than for the defense. Now, very important is there should be no change in methodology for purposes of favoring any party's claim. This is a requirement of consistency. Okay, it's not meant to exclude any changes in methodologies as new knowledge becomes available, nor does it exclude performing calculations based upon a hypothetical. It merely is that the methodologies should remain the same, whether you're employed by the plaintiff side or the defendant. Finally, another principle is in regards to knowledge. Experts should strive to maintain a current knowledge base in their discipline. Well, let's continue to selection of experts, particularly the timing of engagement of experts. My view, and the view of some other experts, is to get the expert on board early, possibly before the suit is filed, but definitely before discovery ends for maximum effectiveness. This will allow the disclosure, so to speak, of the economic merits, damage issues. Potential early settlement might be a possibility as a result of learning more of the economic merits of the case and the level of damages. In fact, one might think potential early settlement might be a cost savings. Getting the expert involved early, you would learn of the extent of damages and the estimate of damages. And by the way, in a survey recently of attorneys, there was expression regarding a strong desire to learn about economic damage calculations and methodology. So by getting the expert on board early, the attorney has a chance to learn of this methodology at a more relaxed pace. At any rate, it could very well be that damages are minimal, and that would be useful to know in advance, or it'd be useful to know early on in the case if your expert is viewing damages to be minimal. With an expert, you have the advantage of being able to identify information that is needed. And it's pretty clear to attorneys often the type of economic information that's needed. But in other disciplines, such as human resources or organizational behavior, the documents needed by experts may not be as clear to the attorney. Well, let's continue. Bringing the expert on board early, the expert can help you prepare perhaps special interrogatories or help with examination questions. Your expert may also have previous depositions or trial transcripts of the opposing expert. Or they just may have experience with the opposing expert and can discuss prior testimony or reports of that opposing expert as a strategy in examination of that opposing expert. Now, when selecting experts, there should be careful identification of these potential experts. Well, let me give you a few. First, a potential expert should be willing to be engaged as an expert. You shouldn't be forcing or coercing them to work for you. Thus, a good expert should be willingly motivated to provide testimony and to be examined from a legal perspective on that testimony. So any newer experts should be made aware of this from the attorney, that they may be under examination regarding their testimony. Which brings me to a related point. A second related personal qualification. We just finished speaking about willingness. That would be the first. The second related personal qualification is an ability to operate under stress. The expert must be prepared to deal with not only courtroom stressors or pressures, but substantial pressures which may be associated with dealing with difficult attorney clients, or I should say, well, those two. There could be difficult attorney clients, but difficult clients of the attorneys. So both may apply. And also being able to handle the pressures of persuasive attorneys and critical real-life issues that the clients may be facing, the clients of the attorneys may be facing. It's not enough that the expert is able to accept these pressures or stressors, but the expert must also be able to continue to operate well under these pressures. The experts and attorneys should be mindful that experts' professional knowledge, ability, and integrity may be, at times, pushed to the limits, right, under examination. But in my experiences, I don't see this as anything too egregious, typically. But for the expert to be aware of this, and maybe for the attorney to remind the expert, especially if the expert lacks many years of experience. At any rate, the third personal qualification is in a possible expert is that the expert must have a high sense of personal integrity. Well, what does that mean? In my view, it's a commitment to honesty and being impartial. Decisions and opinions must be rendered based upon available data as opposed to responding to personal values or demands for advocacy from either side in this adversarial process. So without this personal integrity, the credibility of the expert's testimony rightfully and perhaps quickly might be questioned. Well, this issue is not determined by who has employed the expert, which is an insinuated partiality. Integrity is compromised only by demonstrated acts of the expert who has not used generally accepted procedures or reasonable assumptions, perhaps, or interpreted data in a clearly impartial manner. Okay. Finally, another personal qualification is the communication ability of the potential expert. In small part, this involves the expert's speaking ability, and in large part, the expert's capacity to use language which clearly communicates complex notions, complex ideas, or concepts. For instance, the expert's ability to translate jargon into terms which can be understood and appreciated in the courtroom is very important. Well, let's continue now regarding our careful selection or careful identification of experts. Where there are various sources, personal references, directories, agencies, web search, listings on the web, on websites. It appears most advertise, attorneys do need to know we are in business. References from colleagues work well, but often may not be practical. In other words, your colleagues may not have references for you available. Maybe interviewing experts from various sources is best. Well, you would request professional qualifications and educational background. Often the educational background should include a terminal degree, such as a doctorate, Ph.D. The reasoning behind that is more years of education, obviously, and you've learned more analytical tools. A PhD is a research degree, the plumber's license to engage in research. Some testimony and litigation consulting experience would be advantageous. Your expert could have other types of consulting, more broad experience, in other words, in consulting. Perhaps this is more useful and effective, but not necessarily. other words, it might be more useful or more effective to have this broader range of knowledge, experience, and skills, at least when you're introduced, when the expert is introduced to the court. It shows a broader array of experience. Perhaps that's useful. Perhaps the opposing counsel then has less ammunition in pigeonholing narrow-ranged expert. What I mean by narrow-range expert, that this expert only does litigation work as opposed to other aspects in consulting. We probably wish to anticipate opposing counsel's critique of this narrow range. One critique, and again, I'm not suggesting this is legitimate. I'm just bringing up thoughts on selection methods or criteria. One critique, perhaps, if this expert falls into this narrow range, is that their sole income source is from litigation work. That, in my view, is not necessarily bad. Perhaps they are more serious as a result, as opposed to being a dilettante, where once a year, for instance, they are called to engage in a case as an expert. So I'm giving you both sides. It's not necessarily bad. I know myself, for instance, I know experts that are in this narrow range where all they do is litigation work. And I know experts who engage in both litigation and university work, as well as other forms of consulting. Well, an important criterion really is that the expert is able to answer well unanticipated questions. Okay, this is, you can maybe, in the interview, for instance, ask hypothetical questions and see how well your expert has anticipated these questions. Well, to continue in your identification of an expert, you might be interested in examining whether or not they have peer-reviewed publications. Perhaps they have non-peer-reviewed publications. Peer-reviewed publications are publications in scholarly journals that are written really for those in that discipline. Now, I have mixed opinions as to how useful they are to convey to the court, right? It's important, of course, that your expert does have some experience in the discipline by publishing in the discipline, but it's not the final criterion, really. For instance, publishing in non-peer-reviewed publications, publications where attorneys may read even, or others, that might express the expert's ability to convey information in clear English. So my point is, focusing strictly on whether this expert has peer-reviewed publications or not is not by itself that worthy, okay? They may have some peer-reviewed publications, but they may not be working in the field where they engage in research on a scholarly level strictly. They may be more involved in applied research, okay, where their reports are reviewed and edited, but do not fall into scholarly, necessarily peer-reviewed journals. I hope I did not confuse you on that. So I do think publishing in non-peer-reviewed publications, in other words, popular press, might show that this individual, this expert, has the ability to convey complex ideas in simple English. Another item would be what is their position? Well, some experts, their position is just that. They work as an expert in litigation. Nothing wrong with that. However, other experts have academic positions, and many really do. Now, these academic positions might be tenured, but not necessarily tenured. I'm not sure how how well informed attorneys and the court, including jury, is of this tenure issue, but it's not necessary to be tenured to be an expert witness. Finally, your expert's position could be in the private sector or public sector even. So it's not necessary that your expert is in academia, okay? You know, there are some benefits if your expert is an academic. They have, you know, experience certainly in conveying, hopefully good experience, and they're successful in conveying complex notions in a more simple way to their students. Well, let's continue. Experts from faraway prestigious universities may not impress juries. Perhaps juries prefer local state university, in other words, one of their own. Again, I'm giving you food for thought in your identification of experts, in the process of identification of experts. You might examine on their resume or their vita whether this expert has media commentaries, whether on occasion your expert has been used to comment on a current event for the media. And this goes along with my previous notion. If the expert has this background, in other words, media commentaries, then there's a good likelihood that this expert can convey not necessarily complex notions, but ideas that are relevant to the current event succinctly to the point, because in media they want that. Okay, the interviewer wants the expert's points to be made succinctly, concisely, etc. Then you can look and see whether your expert has honors and awards, or whether your expert conducts CLE seminars, like I am currently. In other words, whether your expert has been a presenter or a speaker at CLE seminars, continuing legal education seminars. Very important, and I brought this up earlier. I brought this up when I was speaking about the principles and ethics of an expert, that they continue development as a professional. They stay current in the field. Well, that largely means that they are members of professional organizations, professional associations, okay? And then finally, but not minimally, is you may not be able to find this information, but you might also be able to. Reputation held by peers. What have other experts say about the expert in which you're reviewing or interviewing, okay? Have other experts corroborated this expert's opinions in court or in deposition? Or is the reputation of the expert, perhaps there was a case where the expert assumed an unreasonable notion? Any rate, so reputation held by peers, that's important, but maybe it's not easy to obtain this information for you or by you. Okay. Well, continuing with the selection process, specifically interviewing. And often the interview is on the phone and not in person. But either way, you could ask the expert for attorney references or references from other clients. Sometimes insurance companies may hire the experts for litigation purposes. And at any rate, you can ask these references whether they believe the expert was persuasive and believable, whether they helped in discovery. Did the expert that you're interviewing, according to the references, point out weaknesses in the economic merits of the case? Did the expert help in the examination of opponents? Were the reports clear with reasonable assumptions? You might learn about what the references think of his or her oral presentation skills, and perhaps, and also important, is the invoicing that took place reasonable? In other words, the fees charged by the expert. Okay. You probably need to determine that if you have an expert that has good experience or has been at it for a while, you probably need to still determine whether the expert is committed for the potential long road. And I would imagine they are, unless they expect to retire before the end of the road is met. In other words, will the expert remain in business? Will the expert be available to update and revise the report and other tasks in short order? A trial date gets moved, or continued, as they say. Perhaps there might be some need to do some minor changes in the report. In other words, does this expert exhibit flexibility? Lastly, you might often check if there's conflicts of interest. Well, I don't think this is such a big deal, really, but it's needed to be careful. The attorney needs to be careful on this, of course, as the expert needs to be careful on this. What exactly, this is a rhetorical question, what does it exactly mean when there's conflicts of interest? My answer to this rhetorical question is, well, the expert is supposed to be an advocate of the truth. So even if this expert is hired by you and the opposing counsel was at one time a client of this expert, or some other involvement, the other side client has some sort of involvement with the expert, ultimately, if we're advocates of the truth, I don't see a problem, because after all, the truth shall set you free. Okay, well, so much for my humor. Let's continue. Well, here's a topic. Fees. Well, I think it's good to ask an estimate for the number of hours your expert may think it would take him or her to perform the work. And of course, you need to know the hourly rates for disclosure. But I don't think the hourly rates are quite as important as an estimate of the number of hours needed. And an expert should provide a range, such as, well, if it's a complicated pension program or profit sharing program or evaluation of future share price in employee sharing of profits, etc. This requires a bit more time. So again, the expert should offer a range depending on information available, issues and availability, and complications. In other words, as I was just saying, stock options, that could be 3 to 4 hours by itself, you see. Defined benefit pensions, that could be 2 to 4 hours as well. Okay. To do the proper calculations and to retrieve the proper information. Okay. We want to also, you may want to also ask, what can be accomplished if cost is an issue? What can be accomplished in fewer hours? You could ask, what is the process involved? What process is involved for this analysis? Okay. In other words, you could ask for details. In other words, how the time will be spent by the expert. I haven't really experienced that, but I don't see anything wrong, being asked that. I usually offer a range and how the time would be spent. There's also reason to have non-refundable or name disclosure or lockup fees. Okay, I find that entirely reasonable and sound economics for the expert. In other words, a name disclosure fee, it could be used for disclosing an expert's name, but thinking to not really engage the expert will perhaps help you in settlement, you might be thinking, and so on. However, one should get some sort of remuneration if your name is disclosed. One idea behind that is well, it's certainly ethical to get paid for using your name if it helps you in the case. But the idea also is that you're locking up the expert by disclosing him or her, and the other side can then not use this expert. In other words, this expert could have lost a potential client, a paid client. So it's important to get paid for merely disclosing the name, a reasonable amount. You could ask for a package deal in negotiation to reduce cost. Portal to portal is reasonable. I think it's also reasonable for the expert to be mindful of the costs of litigation and to keep them as low as possible, but do the best work as possible. Full charge for travel time and waiting time, in my view, of course I could be criticized, usually may not be reasonable. Why? Well, unless you're working on the case while you're waiting to testify, in other words, or travel time if you're working on the case, okay, then full charge, yes. But if you're listening to music or listening to a book being read, then no, I don't think a full charge is reasonable. But I won't belabor this point. The notion, though, is that the expert could be using his or her time for work rather than travel if they were back at home in their office. It's important to clearly state to be immediately notified should the expert anticipate hours above the initial estimate. Okay, I think that's very fair, ethical, and reasonable to ask that. And really, the expert should keep that in mind. If the expert says, I need 10 hours, but then sees it goes beyond it, I think the expert should notify the attorney. Certainly, fees before trial or settlement is reasonable. We know litigation is costly. I see no problem, really, in your asking the expert to discount the invoice if there's some, if settlement is less than anticipated, or if costs are higher than anticipated. Okay. Of course, this could benefit the expert if the work was reasonable and good according to the attorney. Then maybe the attorney would offer a longer term relationship with the expert. I've had some attorney clients for 15 years. At any rate, I think we just need to work together. If there's an issue, we work together. Okay. A serious expert should consider these things, okay? A seasoned expert should know about the costs and burdens of litigation and should want to maintain good relationship with the attorney-client. If you have a problem with the invoice, I suggest do not wait to express your thoughts. Let the expert know. If there's an extensive agreement, written agreement, composed by the expert, read the details. Don't neglect these issues. I'm speaking as an expert to attorneys on this one, right? We read the fine print. I do not personally have extensive written agreement, brief written agreement. Okay. Now, going back to fees for a moment, you know, and sometimes the expert may get some of the fees in advance of the work, in other words, a retainer. And especially with long-term attorney clients, sometimes we have to wait. We know that it costs money, litigation, and it's expensive for attorneys who are financing the case. So I feel we need to be reasonable. Sometimes we have to wait for payment, okay? Sometimes we have to wait for payment. And I think that should be understood by experts, but of course, attorneys should realize that to pay them as soon as possible is also delightful. Okay. For instance, here's an issue. In a recent case, on the plaintiff side, a certain amount was offered in settlement. Okay. A good amount, but it was considered to be not enough. And of course, any good attorney would tell their client that, you know, the jury may not award as much. You might get nothing. So that's the consideration, of course, if you decide not to take the settlement offer. So it turns out that the jury awarded far less in a case recently. Well, now what does the expert do? There's an outstanding invoice. The expert was paid a retainer, but there is still more money owed. And does the expert discount the invoice? And of course, I'm not a tax expert, but there is an allowance for discounting on in your business, right? That helps reduce taxes or helps reduce your profits from your business. Therefore, it can reduce taxes, perhaps. But I was thinking about it. Economic principles are the following. The plaintiff decided to move forward and not take the settlement. Therefore, the expert had to work more in getting ready for deposition or trial and trial. So more hours were put in by the expert. And this is all because the plaintiff, the client of the attorneys, decided to go forward and not accept the settlement. So because of this decision, now the expert could be faced with a quandary. The client of the attorney doesn't have that much money. Does the expert reduce the bill, the invoice? Well, this is a issue not to be resolved here, but I was just giving you some ideas. It's an economic principle involved. A decision made by another impacts, in this case, a decision made by the attorney's client or the attorney as a group decision they may have made to not accept the settlement offer. Now the experts have to work longer hours, and the jury came back with an award that is far less. What's the right thing to do? Well, we'll leave that open-ended. To continue, going back to the selection of your expert, determining oral presentation skills is really quite important, because you're keeping in mind trial testimony, particularly in front of a jury. Is this expert clear, careful, calm, using simple English, and articulate? That is, we can look as an example, does the expert who teaches, for instance, introductory courses, such as in economics, maybe is better suited than one who teaches only graduate level classes? Well, this is just a small little example. And it goes back to something I covered earlier. How can you determine whether this expert can deliver his or her opinions clearly and calmly and carefully? Well, does this expert deliver lectures at an introductory level? Does this expert provide CLE courses in the past? Does this expert do media? Does this expert engage in media commentary when asked? Okay, so that seems to be the most important thing in trial, is clear expression of opinions. Asking questions you anticipate opposing counsel will ask, and what is the reaction from your expert? Asking questions of the expert, such as explaining something complex, and you can gauge whether it's clear and simple to you. In other words, have the expert explain his or her methodology that's employed. Probably want to review hostile questions, unanticipated questions from the opposing counsel. And a seasoned expert may have a better idea, frankly, of what these are. But so would a seasoned attorney who sits in on depots. Okay. Another item might be personal appearance and mannerisms. Of course, this could be gleaned from in-person interviews and not often practical, but maybe there is some video on the internet of your expert. What we're trying to get to is the attire appropriate? Is this expert nervous? Shows nervous motion in a chair. This could lead juries to become uncomfortable. Well, most important would be credibility, education, and experience. A terminal degree, such as a Ph.D. or a doctorate, is best. And really only a few, the whole realm of forensic or litigation support or expert witness, litigation consulting. It's a narrow niche. Not all PhDs or those holding doctorates are up to the task. As we mentioned earlier, a great deal of pressures are involved, and also strategies. So I think experience is as important as education. How many state superior courts has this expert testified in? What federal courts, what other states, state court systems has this expert testified in, etc. Now, credibility also involves clarity in a report or in oral discussion of the report, accuracy of the report. Okay. The substance has to be there. Assumptions need to be reasonable. Okay. Again, I prefer narrative reports as opposed to strictly numbers being presented as in an Excel spreadsheet. I like to think that reports could be read by a layperson and largely understood. Do the opinions provide clear and careful thinking? Look for certain errors. Well, in this case, it might be typographic errors, but also errors in any of the assumptions that you agreed, or between you and the expert agreed to use. Just generally look for any errors that you can pick up on, both in oral discussion of the opinions as well as a written report, if there is a written report. Is there a careful assessment of damages? Juries may be more skeptical of large economic damages, especially with unreasonable or highly questionable assumptions. But juries may also think if the expert is providing really low economic damages, that there's not much of a case. Okay, so there was an article recently written by an attorney regarding how juries get, there's a psychological basis to their awards that they give. And both high requests for damages and low requests for damages don't work as well as middle of the road. Okay, the issue is based on a psychological principle called anchoring. But that's for a different seminar, perhaps. Juries, again, may demand more proof should the awards be rather large or if the assumptions are unreasonable. I think it's important to prepare with the expert for testimony, okay, or examination, or just working with the expert on the analysis, to ensure that it's clear and the assumptions that are used by the expert are what you may have had in mind. And if they're not, you might want to ask. Of course, the expert should not change the assumptions just because you were asked. The assumptions that the expert employs must be considered reasonable. Okay. And that goes back to the selection process again. If you can find references for this expert that state this expert's opinions are reasonable, that's pretty good. Okay. And juries seem to know what reasonable is. Now, preparing the expert for a deposition can be useful. I don't think there is enough preparation between the attorney and expert often in my 25 years at this. One attorney that goes around the country delivering seminars, I remember was stating in his seminars that deposition is argument, trial is argument, therefore deposition is trial. The point is that maybe the case can settle after the deposition. The merits of the case might be more fully disclosed, or the weaknesses might be more fully disclosed. No matter what, it would be a cost saving, certainly, but I'm not here to discuss all of that. Okay, settlement issues. I just was saying that deposition is quite important in reaching a settlement before trial. So therefore, working with the expert on testimony, such as what the expert anticipates the questions might be from the opposing counsel and what that expert's testimony would be like in response to those questions. Well, in preparation with the expert, providing information requested in a timely manner is, to me, very important. Experts may have a questionnaire or use interview questions that need to be answered, okay, depending on the discipline the expert is in. But I use a questionnaire, and that's my starting point, okay? Often interrogatory responses are not helpful to me, and you might understand why, because sometimes the information is not as up to date, or the information is still being worked on, that sort of thing. You know, the responses you offer on interrogatories. I think it's important for the attorney to discuss the facts of the case in some detail. It's more efficient, perhaps, to do this, more effective, and might lower costs, okay, rather than the expert fishing through documents to learn of the facts. But the complaint or amended complaint with a statement of facts would be helpful, okay, to the expert. You want to consider certain questions and queries and doubts and useful ideas posed by the expert, okay? I would hope the expert does this because the expert's an advocate of the truth. In other words, the expert should offer some thoughts, some questions even, queries, or even doubts regarding your case, just to draw out any weaknesses in the beginning, okay? This is helpful to the expert. Again, it's all about the truth, presenting the truth. Okay. Of course, some of these issues might involve, has there been mitigation of loss? Of course, the expert may have some ideas on case law regarding economic damage issues. Of course, you may have more, more case law regarding economic damage issues available. Then there's also discussion of acceptable methodologies that the expert would propose. There's also discussion of what the expert might consider to be highly questionable or unreasonable assumptions. The expert could discuss, for instance, questions that he or she thinks would come from the opposing counsel. There wouldn't be that many, but I like to point out what I think the opposing counsel would examine me on and see what the attorney thinks of my response. Essentially, I'm repeating a point. I think attorneys and experts don't work enough together on testimony. Okay. Together meaning in preparation, anticipating questions, giving effective responses. So I do think This is important to keep in mind, but it takes time, that I realize. However, with a seasoned expert, you could hopefully, and with good references, and if you feel good in your interaction with the expert, then you might be, there might not be as much of a need to go over preparation. But on a recent case, and it's more not the rule, but on a recent case, the attorney showed me the questions that would be asked of me at trial, on examination. To continue, the expert should discuss with you their anticipated rebuttal, or I should say, the expert's anticipated rebuttal by the opposing expert. In other words, your expert, and to be clear, I apologize if I wasn't just now, your expert should be able to anticipate what the opposing expert might try to rebut on. Okay. And be ready for that. Be ready to have the expert be ready to rebut the rebuttal. To continue, you want to make sure the information you provide to the expert is accurate. Expect a follow-up from the expert regarding this information, such as, I might let the attorney know that this is sufficient information, or I have follow-up questions, and here's the follow-up question. In California now, as of September 2016, if I have the date correct, the opposing side can ask for production of documents from the expert 3 days in advance to receive at least 3 days in advance of the deposition. And this has been implemented by some attorneys recently. So if you send the expert a lot of unnecessary documents or lengthy documents, these will be, keep in mind that these will be sent back to you, right? Because you're the intermediary, to send to the opposing counsel. So if you don't want too many documents to be sent back to you, what I'm trying to get to is often attorneys may send unnecessary documents. And of course, some of us, hopefully most of us, are fast readers, and we can use certain technology to locate the information in these thousands of pages of documents you may have sent us, or hundreds of pages. But just being mindful that now here, at least in California, these documents have to be, if the attorney on the opposite side knows of this new rule, maybe I should have discussed it. So that now there's one more tedious task involved. I send the documents back to the attorney, and the attorney sends them to the opposing counsel. Okay, it's a little bit more tedious now, but I can understand this new rule. In the past, I would place the documents on a disk drive or a CD and bring them to the deposition. Okay, to continue, the expert might discuss with you clarification issues, inconsistencies, and missing pieces of information. Inconsistencies in information that's been provided, or inconsistencies in responses by your client, by the attorney's client, right? In a questionnaire or interview question, there might be inconsistencies, and the expert picks up on it and lets you know about it. And we try to ferret out what the truth is, okay? What the fact might be. So that's the expert's job, asking clarification, asking what's the true fact here. There's an inconsistency. what's the truth behind it, okay? Or missing pieces. So that's the expert's job, and I'm sure you're aware of it by now. You might want to prepare your client or legal assistant for this follow-up. You want to inform experts of deadlines and the timeline of the case. Okay. Inform expert of any changes to these in a timely fashion. Well, that reminds me, usually this is done, and we're grateful. But in a case not too long ago, and even a case more currently, the other expert on the case and myself, because we don't hear from the law office regarding any change in dates or the trial date, is it still current, the trial date, etc., or any changes in the timeline, we may leave messages and not hear back. So it's kind of interesting where even during trial, the two experts were communicating, have you heard any information? So a quick little call or email can be quite helpful and perhaps lower costs to some small degree. Okay, to continue, please respond to us in a timely fashion to calls and messages from expert. It might be important. We do have other things on our schedule, other obligations, and we need to plan. That's obvious, as you do too. But we also need to keep in mind, as experts, we need to be flexible with our schedule when it comes to trial, at least somewhat flexible. And the attorneys need to be mindful of our other obligations, work obligations. I think it's important to keep in mind to minimize or be careful with email correspondence. It is discoverable. And you know this better than I do. I guess most of you would know this better than I do, I imagine. And again, the tedious task of preparing for production of documents in this new rule in California, fairly new rule, more emails to produce, more time needed to get ready to produce the documents. Many of these items above, if properly followed, should save time on the part of the expert and lower costs. Clarity, once again, you have a report in your hands or some discussion from your attorney. You want to evaluate its clarity, substance, accuracy. Are the assumptions reasonable? Is the flow good, the flow of thought? Again, I am repeating, look for errors. Is the thinking careful and clear? Well, a little bit more on challenges that may come up to testimony. The Dober challenge or the Sargon challenge, a little bit more recent, that case. These challenges may apply to your case, maybe. I haven't, I've only, in my 750 cases or more than that, really, may have seen the Sargon challenge just once or twice. Okay, and again, this particular case discusses whether the methodology or analysis is scientific enough, okay, or whether it's too speculative. To continue, these challenges may apply, but it's unusual in at least an economic damage assessment. But you want to beware, however, of such things as evaluation. We're talking about economic analysis now. Evaluation of hedonic loss or value of life calculations. These seem to not hold up well in some courts. Okay, in other words, I have seen courts not allow discussion of loss of pleasure of living, the economic evaluation of loss of pleasure in living, or the value of life. Okay. The method of gathering information and evidence is important. The methodology involved in the analysis is important. Has the technique you described, your methodology that you described, the expert described, used? Has it been used before, or validated or tested before? And, generally speaking, in cases I've worked on, these are not an issue. Okay. I haven't seen another expert in my field use a methodology that hasn't been used by me, okay? Or it's a standard methodology. But I have seen experts, on rare occasions really, use unreasonable assumptions, and I let them know about it. That is my job, and that is why I'm hired in part. But that hasn't happened too often, okay? And going back to another point that I've addressed earlier regarding the qualifications of an expert, I have only once that I can recall seen an expert that might be viewed as unqualified, okay? The expert did not have the education in the area, or at least the expert gave opinions that seemed to lack merit. No, it was not in economics. Well, no, not exactly. It was in finance, but the expert was not prepared for deposition testimony, did not do any research, and did not cite any data that was relevant to the case. Basically, an unqualified expert, really, in one way or another. The opinions were a bit speculative, okay, to say the least. Wasn't well prepared. This expert did not have the experience, okay, at all. So the opposing counsel perhaps erred in using this particular expert. Well, let's continue, shall we? So I repeat once again, the attorney should review with the expert anticipated questions for the opposing counsel at trial, but perhaps the expert has a better idea what the anticipated questions might be like from the opposing counsel. Perhaps remind the expert that not having answers for every single unanticipated question from opposing counsel at trial is okay and humble in the eyes of the juries. And, the jury seems to like an expert who is engaged and calm. And of course, the expert should make some eye contact with the jury, as well as with the counsel that's examining the expert. The jury wants to feel comfortable with the witnesses, expert witnesses in particular, perhaps. Okay, and this may further the expert's credibility. Okay. Now, to continue on this, have the judges or opposing experts favorably reviewed your expert's previous reports or testimony, or a piece of your expert's analysis? Perhaps your expert has facts or examples of this that you could use or keep in mind. Whether, in other words, that your expert's analysis has been complemented or just corroborated even by opposing experts. So that's about it on that note. Now, regarding hostile questions, We're repeating a little bit, but repetition is good. Please review potential responses with your expert prior to testimony. To me, the hostile questions, I mean, we have to keep in mind that litigation is adversarial and might really be focused on assumptions and the hypotheticals that the expert used. Perhaps listen to and think about the responses proposed by your expert. Your expert may have some ideas he or she picked up from other experts or attorneys through professional meetings, publications, CLE seminars, etc., and past experience in general testifying or reviewing other experts' reports or responses from other experts regarding your expert's report. Just plain experience. Probably want to emphasize calm, cool, unexcited, thoughtful, same tone responses. Not monotone, but same tone in a different way, a tone where it's not excitable, a reflection of excitability. I think your expert should change tones in a pleasant way, but not get excited from these questions, but change the lilt or the sound of the tone. This is important for any public speaker, of course. And the juries become more alert when the tone is changed. But we do not want to see excitability and nervousness. You want to remind the expert the objective of hostile questions is to perhaps rattle the expert in front of the jury. And the expert should not take it personally, or hopefully it's not personally given by the opposing counsel. I really don't find it useful and never in deposition when the opposing attorney asks, my plaintiff defense ratio. I've never kept track of it perfectly accurately anyhow. And it's never come up in trial after they bring it up at depo. I just don't think it's relevant. That what is relevant, that the methodology that is used is the same, whether it's plaintiff or defense. That should be focused. That should be brought up by you in examination of your expert. Typically, one would think hostile questions might insinuate unethical behavior or lack of credibility. Hopefully those don't come up under testimony, but they may try to insinuate this credibility, lack of credibility, or unethical assumptions, or the term may not be used, but unreasonable assumptions, or they may insinuate, gee, you're a professional and you advertise and you have the following hourly rates. I think this is somewhat disingenuous. Okay, because attorneys advertise and their hourly rates are up there as well. But having expert prepare responses and deciding on the proper response, in your view, is useful. Okay. And I just mentioned, if it comes up plaintiff and defense, what's the ratio? Usually the experts have nothing to do with this ratio. Just this is the work that comes in. More plaintiff than defense, or the other way around. We don't advertise in this way. Okay, that would not be ethical to advertise in this way. But it's nothing wrong to advertise. We need to let attorneys know that we're in business. But the expert needs to be careful with what they state on the advertisement. Often it may appear that the opposing side makes the expert look like a hired gun in whatever language is used. And you need to, again, if that comes up, or prior to that coming up, help prepare a response to that. again, I feel it's disingenuous, okay, because the opposing side more than likely has hired an expert as well. Not often, not all the time. Recently, some cases, the opposing side has not hired an expert, but at least the expert wasn't hired for trial, but maybe for consultation only. So again, have expert prepare responses, decide on the response. You know, in deposition, sometimes we're asked, a lot of times we're asked, how many cases have you worked on with this law office and so on? And well, I may not respond in this way, but you want to keep in mind, I've had the same dentist for 25 years and the same hairstylist, barber, for sometimes 10 years, sometimes 5 years. So I don't think that that a longer-term business relationship has any kind of unethical or connection to not providing the best of possible truthful opinions. Okay. If this is disclosed, for instance, or is brought up in testimony that the expert has worked for the client, attorney-client, for 15 years, then a follow-up question might be, has the expert ever provided analysis to the attorney and the analysis was not so favorable to the attorney's case? Okay, so that could be brought up. And then the answer, of course, would be, in such a long-term relationship, yes, of course. There have been those kinds of cases where you give give opinions to your client, attorney-client, and it's sort of disappointing to the attorney of the opinion. And the good thing would be then the attorney continues to use you. That is ethical. Okay. Well, you know, thinking back on some other cases in the recent past, without discussing too much of each particular case, you know, make sure your client gets moving on the information that is requested by the expert. Sometimes your client might be emotionally bereaved and doesn't feel like working on the case, but providing information that is the client, that the expert is asking, tell them that the sooner that they get it done, the easier it would be, and this is imperative that they get the information. To communicate the timeline of the case, if you're in trial, what's going on, you know, communicate a brief email. Okay. On a recent case, in December, well, I should say a couple of months ago, I was to be retained, but I haven't heard back since until most recently. In other words, what I'm trying to say is the law office is putting a time crunch on the expert, and that's not good, especially if the case is complicated and the expert has other cases to work on, other work obligations. So keep in mind that if you agree to a retainer before further work is to be completed and the retainer hasn't been sent, then don't expect the work to have been done. If you haven't communicated, gee, we can't send it after all, money's tight, or if you haven't communicated in 1 month, it's difficult for the expert to pick up from where they left off a month prior, because now that expert may have other work obligations, other deadlines that he or she is facing. So, you know, this comes down to communication, quite frankly, proper communication. Well, that's about it for today. Hopefully you'll join us again for other seminars, and I wish you well, and thank you for joining us. I hope you learned a lot. and are able to use what you learned in your cases. Bye-bye now. And you can shoot me an email if you have any questions or thoughts regarding the information I've provided, or if you need some clarification. Okay, thank you again. Bye-bye.